So far, we have talked about the following purposes of contract law. The first purpose of contract law is to enable people to cooperate by turning games with non-cooperative solutions into games with cooperative solutions. The second purpose of contract law is to encourage the efficient disclosure of information within the contractual relationship. The third purpose of contract law is to secure optimal commitment to performing. We now turn our attention to the fourth purpose of contract law, which is to secure optimal reliance. We will also cover the fifth purpose of contract law, to minimize the transaction costs of negotiating contracts by supplying efficient default rules. Reliance is the action taken by the promisee based on the belief that the promise will be fulfilled. Here are some examples. Tesla signs a contract to buy a large quantity of batteries from another manufacturer. In anticipation of buying the batteries, the battery manufacturer builds a new plant. Here's an example from the problem that we have been working through with Allison building a boat for Betty. Betty is counting on the boat from Allison, so she signs up for sailing lessons, has a dock and boathouse built at the cabin, and purchases other supplies. Not all reliance is efficient. When assessing whether reliance is efficient, we want to look at the reliance from a societal point of view. In many cases, the reliance that will make the promisee best off is not what is best for society. Reliance is efficient if the societal benefit is at least as great as the social cost of reliance. The question for the courts and policymakers is, how should reliance figure into damages? When a promisee relies, it changes the benefit of the contract to the promisee. Recall from the last video we learned that expectation damages equals the expected benefit of the promise to the promisee. Since reliance increases the promisee's benefit from performance, the reliance also increases expectation damages. This can create a perverse incentive for the promisee. Even if the probability of default is high, expectation damages creates a strong incentive to rely because the promisee can count on being awarded the higher damages even if the promisor breaches. To better understand how not all reliance is efficient and how expectation damages can create a perverse incentive, let's return to our example of Allison and Betty. Before Allison receives the boat from Betty, she needs to get a boathouse built at her cabin so that the boat will be protected from the elements. Recall that she values the boat at $550,000 and is paying Allison $400,000 for the boat. Boathouses can be relatively inexpensive or expensive. The price of the boathouse she chooses is $50,000. After building the boathouse, the value of the boat and the boathouse will be $650,000. Explain how building the boathouse changes the value of Allison's promise to build a boat. Before Betty built the boathouse, the value of the promise was $150,000. This is because the value Betty placed on the boat, $550,000, was $150,000 more than the price of $400,000 that she agreed to pay. Now that she's building the boathouse, the value of the promise is $200,000. After reliance, the combined value of the boathouse and the boat is $650,000, which is $200,000 more than the combined price to Betty of the boathouse and boat. If Allison defaults, how much would she have to pay if expectation damages cover the total amount Betty loses? Or in other words, if expectation damages equal the value of the promise to Betty. Reliance increased the value of the promise to Betty to $200,000. Thus, reliance increased the expectation damages by $50,000 to $200,000. So Allison is building this boat, and there is a risk that her costs increase, maybe because of something like a global pandemic of COVID-19 coming out of nowhere and disrupting transportation. Before Betty builds the boathouse, Allison would have to pay damages of $150,000. After Betty builds a boathouse, Allison would have to pay damages of $200,000 if the courts awarded expectation damages. This shows that Betty is not the only one that bears a cost from her actions to rely. When Betty relies, she imposes an expected cost on Allison. Because Betty built a boathouse, COVID-19 suddenly got more expensive for Allison. If the probability of performance is 0.10 and Allison must pay perfect expectation damages if she defaults, will Betty build the boathouse? Calculate Betty's expected benefit of building the boathouse. Betty will rely if this weak inequality holds. The left side of this inequality is the promisee's expected benefit of reliance. The right side is the promisee's expected cost of reliance. The increase in benefit from reliance is $100,000. The problem gave us that the probability of performance is 0.10. The increase in damages from reliance is $50,000. The probability of breach is 0.9, and the cost of reliance is $50,000. Putting this all together using the equation given, we see that Betty wants to rely when the courts award expectation damages. That is, for Betty, the expected benefits of reliance outweighs the cost. However, this is not efficient. The probability of performance is too low. The problem is the second term of the left side of the equation. It is good for Betty to consider the first term of the inequality because this is the social benefit from reliance. However, Betty relying on the return represented by the second term is not legit from a social perspective. This is building the boathouse because she will get more damages in the event of breach, not because there is an actual benefit to having a boathouse if Allison breaches and Betty does not get a boat. It is efficient to rely if this equation holds. This utilizes just the first term of the previous equation. That is, it is efficient to rely if the social benefit is greater than the social cost of investment in reliance. If you actually calculate the numbers for Allison and Betty in this example, you will see that it is not efficient for Betty to rely. So we see here that expectation damages creates an incentive for Betty to over-rely. How do we fix over-reliance? Theoretically, the answer is perfect compensatory damages. Here, the promisee is compensated for losses up to the amount that would be incurred when reliance is efficient. This can be hard to calculate in reality. For starters, what is the correct probability of performance? In practice, the courts award damages based on foreseeable reliance. Foreseeable reliance is the amount of reliance that the promisor could reasonably expect the promisee to engage in based on expecting to receive the promise. Now we have addressed the fourth purpose of contract law, to secure optimal reliance. We will now turn our attention to the fifth purpose of contract law, to minimize transaction costs of negotiating contracts by supplying efficient default rules. Efficient default rules can produce significant cost savings when contracting. Default rules fill gaps in contracts. Gaps are risks or circumstances that are not specifically addressed in a contract. Some circumstances are entirely unforeseen. Even if everything was foreseen, transaction costs can make it expensive to negotiate over every conceivable circumstance. It can be rational for the parties to leave gaps in the contract because the costs of contracting outweigh the benefits of contracting. The choice here is between allocating ex ante risk versus ex post losses. By ex ante risk, we mean the risk of future losses faced by the parties when they negotiate a contract. By ex post losses, we mean the losses that actually materialize after making the contract. By writing a term into the contract, the parties are allocating risk ex ante before it becomes a loss. By leaving a gap, the parties are choosing to allocate losses ex post, or after the losses materialize. Our goal is to minimize transaction costs. The parties want to leave a gap in the contract when the cost of allocating risk in the contract is greater than the expected cost of allocating losses after they actually occur. We want to fill or negotiate the gap in the contract when the cost of allocating risk in the contract is less than the expected cost of allocating losses after they actually occur. As an example of this, consider the following example. Betty contracts with Allison to have Allison build a boat. Allison knows that there is a 20% chance that material prices increase by $50,000 before Allison needs to purchase them. Betty is not aware of this possibility. Allison can hedge against the risk for $4,000. Suppose that it costs the parties $1,000 to negotiate a contract that covers the possibility of material prices increasing $50,000. Is it efficient to allocate the risk by writing a term into the contract regarding material price increases? The answer is yes. This is because the cost of allocating the risk in the contract is $1,000, while the expected cost of dealing with it ex post, or in other words, after the fact, is $10,000. Another reason why it may be rational for parties to leave a gap in the contract is because the courts have established efficient default rules. Default rules are the rules applied by the courts to fill gaps. An efficient default rule is one that the parties would have agreed to had they written the rule into the contract in the first place. If the courts follow the practice of consistently filling a specific gap in a contract with a specific default rule that is efficient, then the parties can avoid the cost of contracting over the rule by leaving it out of the contract. If parties do not like a particular default rule, that is, if the default rule is not efficient, the parties can negotiate their own rule as a term in the contract. When the parties write a term into the contract that contradicts a court default rule, the courts will always enforce the explicit term in the contract. Let's return to our example of Allison and Betty. Suppose that the courts follow a rule to apply the risk of an increase in material prices to whoever can bear the risk most efficiently. First off, who is the efficient bearer of risk? The efficient bearer of risk in this example is Allison. That is because she is in the best position to be able to respond to the risk. Betty is not likely to know about the risk of material price increasing, and there is not much she can do about it. As a general rule, the party with control over some part of the production process is in a better position both to prevent losses and to predict them. It follows that an efficient contract will usually assign the losses associated with something going wrong to the party with control over that particular something. If the parties know this rule at the time they are contracting, should they write a contract that has a term on material price increases? No. We found before that the most efficient thing is for Allison to hedge against the risk. If the default rule is to apply the risk of an increase in material prices to the efficient bearer, then the default rule is already applying the risk to Allison. There is no need to incur the $1,000 cost of writing it into the contract if that is what the court's default rule is anyway. If the courts were following an inefficient default rule, then the parties could write a term into the contract, and then the courts would disregard their default rule in favor of the explicit term in the contract. How should courts come up with default rules? Economics offers this simple rule to courts to identify efficient rules. Impute the terms to the contract that the parties would have agreed to if they had bargained over all the relevant risk. This is what we call a hypothetical bargain. It is Pareto efficient because the parties would not have agreed to it had it made at least one party better off without making the other worse off. To avoid ambiguity in the law, the courts often follow the majoritarian default rule, which is to set the terms that most parties would have agreed to. This is because default rules cannot vary with every case. In instances where default rules would not be efficient, the parties can override the default rules by writing their own terms into a contract. So this concludes our discussion of the fifth purpose of contract law, to minimize the transaction costs of negotiating contracts by supplying efficient default rules.